Okay, well, thank you all for staying for part 2 of our event today. Now, what I'd like you to imagine is that our panel of collegial debaters have been transformed in front of our eyes into an intimidating set of sharks. Our sharks today will be listening and commenting on case presentations from 5 of our very own young ICCA colleagues. The task before the presenters is to convince the sharks, and indeed those of you here in the room, that their selected case is the most significant decision in international commercial arbitration since the last ICCA Congress in Sydney in 2018. The presenters with us here in the room today have been selected through a competitive process where applicants were asked to submit blurbs setting out cogent and compelling reasons for choosing their cases. I have to say, one of the privileges of this job is the opportunity to give talented individuals like this a platform to flex their oral advocacy muscles in front of what I hope will be a testing, but not too testing, panel of sharks. You will see that we also have the pleasure of being joined by an additional shark, Kate Brown de Vecha, for this segment of our event. Kate is a partner and global co-chair of international arbitration at DLA Piper. She is an Australian and New York qualified attorney and has been resident in Mexico City for the past 13 years. She's represented clients in a wide range of commercial and investor state arbitrations and is herself a former co-chair of Young ICCA. We're very pleased to have you, Kate. Thank you for joining us. So now we move to the fun part. We've agreed a random order for our presenters. First up, we have Jessica van de Kamp, who is a senior associate at Mayer Brown in Hong Kong. Jessica has experience in contentious construction, town planning, and general commercial disputes. She has been involved in a number of arbitrations for large infrastructure projects and judicial review against town planning decisions. As you will have seen, we also have the pleasure of being joined by Jessica's 4-month-old daughter, Naomi, who I understand is the youngest member of Young ICCA in our history. Young. Jessica will be presenting on a VIAC decision from December 2017. The floor is yours, Jessica.
Good afternoon, everybody. As you see, there's 2 of us in the Shark Tank here, and please excuse me if she gets a little chatty. Hopefully, it's only one of us doing the talking today. The decision, I think it's interesting that earlier Manas referred to cases that we were going to present on, but actually what I'm going to present on is, it's not really a case, it's a procedural decision. In fact, I'm not even sure it's a decision. I don't know much about it. I don't know the parties' names. I don't even know what it's called. And there isn't even a proper citation. But just for the sake of staying on the fringes of this topic, let's just call it the decision. And it's decision number 61 of the Vienna International Arbitration Center. And it related to the appointment of Andrea Meyer as the chairwoman of the tribunal, joining Jurgita Kute Gurnia and Lucia Raimanova. Excuse me if I've butchered the names a bit. I'm not very good at those. But the problem is, this is all we know about this particular case. So why is it significant? It's the first ever, at least reported, all-female tribunal that we know of. But actually, that's not really significant if you think about it, because really, what is so diverse about a 3-member female tribunal? It's actually not diverse, it's very female. So let's take a step back. We all know that certain segments of society is overrepresented in international arbitration and in the appointment as arbitrators. And in 2015, there was the Equal Representation in Arbitration Pledge. And it was wonderful because lots of law firms, arbitrators, arbitration institutions have signed up for it. And it shows that the arbitration community is very progressive-minded, and it's wonderful. But we have a problem. Arbitration is party autonomy, and quite honestly, if the parties don't want a particular characteristic, there's nothing you can do about it. It's party autonomy. So this decision, quote unquote, is significant because it was the first time we know of where full confidence was expressed by parties in women to deliver justice. And so that is significant. But as I said, 3 women are not particularly diverse if you think about it. So why is it really the most significant decision? Now, previously I said that we don't know much about this decision at all. Actually, there's a little bit more we know because one of the arbitrators did make some comments in an interview later on, and she said, in this case, my co-arbitrator and I made sure we had an equally qualified male candidate for the role of chairman. But as luck would have it, we ended up with a female. And this is the point. Luck. It was luck. It was chance. It was coincidence that delivered an all-female arbitral tribunal. And this showed that... She agrees. This decision is the most significant because it shows that the gender of an arbitral tribunal has now reached a state where it's random. It's based on merit. It's based on your what your skills are. And this is ultimately what the push for diversity is about. Randomization of qualities and characters in arbitral appointments. Thank you.
So the Sharks will now have 5 minutes to ask any questions that they would like to of Jessica.
First of all, can I congratulate you on the mummy wiggle? I remember it very fondly. Secondly, a quick question: what do we know about the manner in which all the arbitrators were appointed? The mechanism that was used. Do we have that information?
I was able to decipher a bit. I tried to look at the Vienna Arbitration Center rules, and it seemed that it's parties that appoint it. But if it's, I think if it's a tribunal, then co-arbitrators will appoint the chair. And it seems that this was what the case was. But then it was a bit strange because it was one party appointed one arbitrator, and then the other one was by the tribunal. So I suspect that arbitrator who was, sorry, not by the tribunal, by the institution. I suspect what happened is one of the parties actually didn't participate in the decision-making process. So yes, I've slightly twisted things around to work for this Shark Tank, and you've caught me out on that.
And then, do we know what the reference was by luck? Was it that they had agreed on, a potential male chair, but that person had a conflict or was unavailable, and then they went to their second candidate? Do we know what that was?
I've searched up and down for this. I can't find any more. It was just this statement in an interview that one of the arbitrators gave, and she just said that they tried to find they had an equally qualified male candidate for the role. So I think it was between the two. And I don't know how between the male and the female it got to an all-female tribunal. I don't know if the parties somehow were involved. There's no further information. But she did, the word luck came from that arbitrator, which is why I thought that's the significant point about it.
And I just have one further question, which is, why is this particularly significant in an age where we have, the ICC publishes its data on arbitral appointments. Not all institutions do that, but we do now get a lot of information about who's being appointed. Why is it novel that we knew this and that it's the only one we know of? It may not be the only one ever, but in this day and age, was this more significant back? When was this award?
Well, the appointment decision was December 2017, so actually technically before the last ICCA. But it came after the 2015 arbitral pledge. And I think at that point, the IAC was working towards more diversity. And after they had informed the world through their annual report of this decision. I think I don't have it on me, but I think the statistics, it went up the next year and it's been going up. And I think most recently they had the most impressive statistics on appointment of female arbitrators, whether sole or in a tribunal. So I think that's where it's part of the whole process of increasing diversity. Again, hopefully it's as a result of luck and chance rather than specifically to positively discriminate.
Jessica, you and your assistant have submitted that it is not particularly diverse, but I think you are limiting only to gender diversity, because if you look at the nationalities, I find it pretty diverse. Sorry that I stole your question. Slovakian, Swiss, and Lithuanian. That's not bad for Europe.
Yeah, it's not bad for Europe.
When it is taking place in Vienna, yeah. I don't know where the parties are from, of course.
Yeah, and I actually thought about that. It's not bad for Europe. That was impressive. Nationalities. I suspect language might have had a play in that as well. I don't know much about those the three arbitrators and their ability to speak, I assume, German, but I don't really know. So yes, yes, there's diversity in nationality. I think the point is, in terms of gender, it showed randomization, potentially in terms of nationality, but it'd be good to see randomization in all aspects of all aspects of diversity, I think. I think it would be very unusual if somebody like myself from Hong Kong were to be appointed to that tribunal, though it wouldn't make any sense.
Very good. Thank you, Jessica. Great. So next up, we have Rahul Donde. Rahul is counsel at Levy Kaufman Kohler. Over the past 11 years, he has acted as arbitrator, counsel, secretary, and assistant of the arbitral tribunal in over 35 international arbitrations under both ad hoc and institutional arbitration rules. Rahul's worked in Switzerland and India for several years and has expertise in complex commercial and investment disputes in both common law and civil law systems. He also sits as an arbitrator. Rahul is going to present on the 2021 decision of the Supreme Court of India in Amazon Holdings and Future Retail. I understand Rahul's got some slides, so if those could go up on the screen. And apologies to the sharks, you might have to just twist around to see these as he is presenting. So Rahul, here's your clicker.
Colleagues, sharks, I'm here to present to you why the decision in Amazon Holdings versus Future Retail is the most significant decision since the last ICCA Congress. Before I begin, I wanted to say that this morning we heard a lot of the sharks talking about philosophers of past and quoting from them. So I thought that to make my point, I should do the same. And I present to you a short video clip from an incredibly important personality, the most watched TikToker, who makes my point well, if it works. So sharks, I wanted to make 2 points here. If you want to eat the banana, just peel it. You don't need to complicate it. Simple is easy. The second point is that Khaby Lami is the most followed TikToker and a multimillionaire. That's relevant. Okay, so what the Indian Supreme Court did in Amazon versus Future is very simple. Doesn't mean that it's not significant. Doesn't mean it's not relevant. What it did, it was answering two questions. The first question, is emergency arbitration contemplated by the Indian Arbitration Act or not? and the Indian Arbitration Act is based on the UNCITRAL model law, so it's relevant for all model law countries. That's the first question. The second question, if it is, then can we enforce an emergency arbitration decision as an order of the court or not? And the court followed a very simple interpretive exercise. It looked at the Arbitration Act, it looked at the various proceedings of the Arbitration Act, and found here a few extracts where the court said that there is nothing in the Arbitration Act, and again, that's based on the model law, that precludes emergency arbitration from the scope of the Act. Party autonomy instead is emphasized in the Act, and therefore, if the parties choose through institutional rules to have emergency arbitration, then that decision should be recognized and does fall within the ambit of the Act. That was the first question. The second question that the court turned to was whether that emergency arbitrator's decision should be enforced or not. And again, the court followed a very simple interpretive exercise. It compared 17(1) of the Indian Arbitration Act with 9(1) of the Indian Arbitration Act and said that if a court's decision granting interim relief can be enforced as an order of the court, there is no reason why an emergency arbitration award or decision cannot be enforced in exactly the same manner. Two simple points, a simple interpretive exercise. The result, though, is extremely significant. Why? All of the countries in blue are UNCITRAL model law jurisdictions. All of the countries in blue have based their arbitration legislation on UNCITRAL model law, on the UNCITRAL model law, and all of the countries in blue can look to the Supreme Court for guidance on how to interpret and apply their respective legislations to enforce emergency arbitration awards. Everyone wants the banana. The Supreme Court shows you the fastest way to get to it, and the most economical and the most profitable. Thank you.
Rahul?
Yes.
The decision is not significant because, right? It says nothing about foreign-seated emergency arbitrated award, right? It's just India-based. So because there is no equivalent.
I can respond to that.
Yeah. So address that question.
It does. So what? I'm sorry. It deals with an arbitration which is seated in India. That can be international arbitration seated in India. Doesn't matter. So what if it doesn't deal with a foreign-seated arbitration? It deals with a narrow question of an arbitration which is seated in a particular country where the UNCITRAL model law applies. And it tells you that UNCITRAL model law contemplates emergency arbitration and also allows for an emergency arbitration decision to be enforced as such. It doesn't decide something else, but if it doesn't decide something else, that doesn't weaken the strength of that decision.
But I have a follow-up question on that. Sorry, I said it. But why did you show the map? Because New York Convention is not applicable, is it, in that case?
No, I showed the map just to show you what UNCITRAL model law, how many countries in the world have adopted legislation that is based on the UNCITRAL model law.
And the story, do you have to then explain again to me, maybe, why is it then significant, the Indian decision, is it significant for the other model law countries?
Because
there's no link, because you have the Indian Arbitration Act.
Yes.
If it would have been a New York
which is based on the UNCITRAL model law.
Then maybe we could talk about it, that it has an impact. But like this?
Well, I look at the common link being based on the model law. So the model law is the common line that underlines all of these jurisdictions. And yes, there are variations, but the Supreme Court does show you a path to be followed whenever your arbitration legislation is based on the model law.
Would you accept it would be a more significant decision had it addressed, even obiter, the question of foreign-seated emergency arbitration enforcement in India?
I don't think it could have, because that was not the facts before the tribunal. But yes, I suppose it would have been, had it. But in the factual context of this case, there was no room for the Supreme Court to do that. And I think the Supreme Court shouldn't do that. And arbiter is not really, well, depending on which jurisdiction you go to, arbiter is not really relevant. Sure.
Okay, so 2 questions. You reminded me that for a period of time, I used to have a lot of students wanted to do dissertations on enforceability of decisions made by emergency arbitrators. So there must be a contrary position towards that simplicity of peeling the banana. So I guess that's the reason you brought this forward to us. So what is the other side? So why would my students want to write a dissertation? Why do you think India made it simple for the rest of us? There must be something that you thought it was very complex, and somehow what the Indian court did are resolving the problem. So that's the first leg of my question. And then the second, which I might have missed, and I'm very, very sorry, is there any foreign element to that case? So are parties Indian, applicable, everything is Indian related, or there is some international element?
No, it is seated in India, but to be seated in India, it does not need to be domestic. You can have an international arbitration, as it was, seated in India. So that answers the second part. As far as the first part is concerned, the first point is not every jurisdiction in the world is a model law or a model law based jurisdiction. So for those jurisdictions that are not, I think that there is enough material to understand whether in that particular context that should be whether an emergency arbitration decision falls within those particular legislations which are not based on the model law. And even within the model law jurisdictions, there has been some divergence on the approaches that the courts follow. For example, in the US, emergency arbitrator decisions are not automatically enforced. And there is a decision of at least 2 district courts, I believe, that have found that it is not included and does not fall within the scope of the particular arbitration legislation that they are applying. So I by no means mean to suggest that nuances don't have to be paid attention to. They do. But if you're simply applying provisions which are analogous to or similar to the Indian provisions, which are essentially rooted in the model law, then I think the Supreme Court provides a very clear, very straightforward, very easily adaptable reasoning that can be adopted by different courts.
So if you were to advise the Indian government, because they are due to draft their new arbitration act, and if they ask you, do you think we need to include an explicit provision allowing emergency arbitrators, what will you answer? Would you say, no, it's good enough, that decision that...
I would say that legislative clarity is always appreciated, but in the Indian context, the Supreme Court decision is the law. So we do have arguably the law now where in a domestic arbitration, an emergency arbitrator's decision can be, I mean, I shouldn't say domestic, I should say in an arbitration which is seated in India, an emergency arbitrator's decision can be enforced as an order of the court automatically. But again, legislative clarity may be useful, and to Baiju's point, it might be useful also to clarify that the same applies for foreign seated arbitrations, and some jurisdictions have done that, like Singapore, New Zealand, Hong Kong, and the others.
Can I ask a
Yeah, sorry.
I'm hiding behind the screen. It was just to say, this may require a level of speculation on your part, but do you think you can extrapolate anything from that decision? Would it be of interest to the Indian courts if the jurisdiction where the arbitration was seated did not treat or did not enforce the emergency measures? For example, in the US that you gave, so if the arbitration was seated in the US and the emergency measure was not enforceable by the courts in the US, could they take it to India and enforce it there?
Do you mean if there was if the tribunal, instead of being seated in India, was seated in the US, would it be enforceable in India? The answer is currently no. Very clearly. The scheme of the Act, of the Indian Arbitration Act, does not currently allow for a foreign seated emergency arbitrator's decision to be enforced. And arguments have been made that should not be the case. And there is unfortunately some judicial precedent in other cases, not this one, that would lead to the opposite conclusion. There's no clear dictum by the court, but that seems to be, if you read together 2 or 3 cases, currently a foreign seated emergency arbitrator decision will not be enforced automatically as an award in India.
Thank you very much.
Okay, next up we have Daria Shailova. Daria is currently pursuing her LLM in the field of international and comparative law as a double degree student at the University of Zurich. and Berkeley School of Law in the US. She was recently awarded a BA in International Law from the Yaroslav Mudry National Law University in Kharkiv in Ukraine. And Daria will be presenting on EMEC and WTE Group and the European Commission, a decision that was rendered by the Brussels Court of First Instance in 2021. Over to you, Daria.
Thank you. That's me indeed. And I must say it is a very great pleasure for me to be here today. I attended my first ICCA workshop 5 years ago as a freshman, and now I'm here in another capacity as a speaker, which is very nice. And without further ado, I present to you, ladies and gentlemen, the European Commission versus AMEC and WTE. So just by the show of hands, how many of you here are in fact familiar with this decision? Okay. I know the ICCA did in fact a webinar series where they elaborated in this case, but then I'll just go on and explain a little bit further into the procedural history so that you could in fact understand what I'm talking about. So the case itself is fairly simple. What happened is that in 2009, 2 contractors were awarded a construction contract by the European Commission, and the value, as you can see, was 10.7 million euro, which is not even that much. And then what happened, the contract was, by the way, for the construction of sewers and hydro pipelines in Cyprus. And what happened was that in 2012, they discovered some construction defects, and the dispute arose on that ground. Then they tried to submit it to expert determination, but unfortunately that didn't work out well. So what happened then is the European Commission commenced arbitration against the contractors. And the clause itself was fairly standard. It was the ICCA arbitration. The seat was in Brussels, and the substantive law was the Belgian law. And the dispute was to be adjudicated by a 3-member tribunal. And the arbitration itself proceeded rather smoothly, I would say. So in 2012, the tribunal rendered a partial award, whereby they allocated liability for defects at 60% to contractors, namely AMEC and WTE, and at 40% to the European Commission. Now, the interesting part begins here, because apparently the contractors, the respondents, in the present case, they disagreed. And what they tried to do was they tried to set this award aside at the seat, namely in Brussels. And their claims pertained, before that, they requested a number of qualifications from the tribunal regarding the involvement of the tribunal secretary in the drafting of the partial award itself, in addition to the questions which the chairperson posed to the expert witness at the hearing. And they even went so far as to alleging partiality on behalf of the chair. And further, they also requested various documents from the ICC itself, from the institution, which is, I think you will agree with me, rather unusual and aggressive, if you would. So basically, what was happening at this point, I think you can guess from the picture. And subsequently, the chair then resigned, commenting that the manner in which the parties were proceeding was inadmissible and indeed unprecedented. So the contractors then moved their case to the responsible court, which was the Brussels Court of First Instance. And the claims they were making were under Article 1717 of the Belgian Code of Civil Procedure, which is in fact a verbatim adoption of Article 34 of the UNCITRAL. And basically what they did was argue that because the award was drafted by the arbitral secretary, the intuitu persona mandate of the arbitrators was breached, and hence the procedure was not, in fact, in agreement, in line with the agreement of the parties. So they moved to set the award aside. And this case was decided, as I said already, by the Brussels Court of First Instance in 2021. And by the way, the review by the Supreme Court is still pending. So, in fact, I must say, this is not the end to this saga, but I think we can all agree that this is very unlikely that the Supreme Court will, in fact, remand this decision. So now we jump right into the issue before the courts, which was, can an award be successfully challenged on the ground that an arbitral secretary was involved in the drafting? And as some of you may know already, the Brussels court said no. Why did the Brussels court say no? Well, they said that, in fact, for the award to be unenforceable, there must be illegitimate delegation of power. And the mere fact that the tribunal secretary was involved in drafting does not in itself constitute this illegitimate designation. So in fact, they set this threshold rather high. And so from this, it's followed that the intuitu personae character of the mandate was not breached. And just to be clear, this intuitu personae character means that the arbitrator mandate is in fact non-assignable and non-transferable, and it should be the arbitrators themselves who decide the case, not the, the secretary, the witness, the counsel, or whoever else might be involved with the case. But I think everyone already knows this in here. What was also very unique about this case is that the court interpreted the 2019 ICC note on the conduct of the arbitration, and in particularly they examined paragraph 887 of the note, which basically prescribes that a request by the tribunal posed to the secretary to prepare some research or a legal memoranda on various issues that might pertain to the case does not, in fact, release the tribunal from its duty to personally review the file and to render an enforceable award. Now, I invite you here to step a bit aside from the case itself, because the reason I actually included this slide in here was that I couldn't help wondering about the issue I'm about to present to you while I was preparing this presentation. So here you could actually see the requirements which are posed to the arbitrators by various arbitration institutions or arbitral laws worldwide. And you might actually see with some recurrency such words as recognized competence, leadership in a certain field. And I think the SIAC even goes as far as to stipulating that the prospective arbitrator has to have 10 years of experience and some other recognized publications or whatever that may be. So I think everyone here can agree that it is not easy to become an arbitrator. And in fact, some people wait years for their appointment. So considering all this, does it really make sense that a reasonable tribunal would allocate the ultimate decision-making power to a secretary who, in fact, does not boast those competences and years of experience? Doesn't seem like to me. In fact, this can hardly happen, which is why the court set this threshold so high in this case. And now I think we should skip that for the sake of time. And I move to the key takeaways of this case. Why do I consider it to be the most important? Well, first and foremost, it provides for greater procedural transparency and integrity. Because, I mean, if the parties in the tribunal agree from the very beginning what the permissible tasks are, then this leaves very little room for fishing expeditions or other dilatory tactics that the party, in fact, who is not satisfied with the outcome, might want to engage post-award. And second of all, this issue is universal. I mean, it is relevant throughout all jurisdictions, UNCITRAL, New York Conventions, Vespila, whatever it is, you name it, this issue is relevant. Because all across the globe, tribunals in fact rely on tribunal secretaries, and this has become by now standard practice. Then, what is also worth to be mentioning is this can become a driving impulse to updating institutional rules and even possibly a national legislation. But of course, this will be in the years to come. But for now, this case provides a ready solution to the problem which we are already experiencing now. And last but not least, it is very much recurrent with the theme of this Congress, namely enlightenment and embracing positive change.
I can go. So I gave a quote in GAR on this topic, and I said, I'll just read out what I said. While the Belgian court appears to have found comfort in the fact there was a review and revision process that fails to ask the key question, who decided what will be written in the first place? If the tribunal secretary did, no amount of review or revision afterwards changes the fact that the parties' expectations are not met as to who decided the dispute. So what I'd put to you is the question, is it significant because the Belgian court didn't or couldn't really investigate who did what, when and how in an evidentiary fashion, but accepted the fact that if there was a review and revision process, then that was sufficient to meet the threshold that the arbitrator had fulfilled his or her mandate.
Indeed, and this concern is in fact very relevant. I mean, this all comes down to the exercise of intellectual power, and it is very hard to prove lack of presence thereof. But if, in case when it is clear from the beginning that it is in fact acceptable for tribunal secretaries to draw up at least non-substantive portions of the award, then, as I said, this leaves very much room for dilatory maneuvers. And this also sets up predictabilities for arbitrators themselves. I mean, in case, I mean, this is very unlikely to happen, but in case where there is illegitimate delegation prior to the award being rendered, then this can result in challenge and removal from the panel.
Can I do a follow-up? Which is, it seems to me that we've separated, we say, the decision-making process and the writing of the award. But I think I think it was Donald Donovan gave an interesting keynote discussion at the ITA in Dallas. I think it was still in Dallas at the time, where he said actually writing the award is part of the decision-making process because you have your impressions, you have what you saw at the hearing, you've read the transcript, but actually then when you draft the award, you see what works in terms of your legal reasoning, your analysis of the fact. So actually the exercise of drafting is part of decision-making. And it seems to me that that is not an aspect that was really discussed in the decision.
Indeed, this is true, but some argue that the ultimate exercise of this intellectual decision-making process can even be shown by signature. So ultimately, this depends on which side of the doctrine you want to stick on. But again, as I have emphasized already, it is very important to leave as little room for such dilatory tactics as possible, and this decision does just this.
Okay, our penultimate presentation is from Robert Bradshaw, who we've already heard name checked in the first part. Robert is an associate in the London office of Lalive, where he practices international commercial and investment arbitration. He has acted as counsel in arbitrations under numerous arbitration rules, and he's also a solicitor advocate holding higher rights of audience before the English courts. As well as participating in Young ICCA, Robert is also the UK Vice Chair for the Young ITA, the under 40s branch of the Institute for Transnational Arbitration. But we won't hold that against him. Rob will be presenting on the Swiss Federal Tribunal's decision on the 16th of October 2018 in Ukhnafta and Russia. And I think he has some slides as well.
Thank you very much. I'd like to take you back to October 2018, when the Federal Tribunal, that's the highest court in Switzerland, upheld a jurisdictional award in favor of Ukhnafta, a Ukrainian business, against the Russian Federation. And a lot has changed in the 4 years since that decision, but as I'll explain, that decision is more relevant than ever today. I should also have a quick disclaimer at the start as well, because Lalive acted in that case, but just to clarify, I wasn't on the council team, and these are my personal opinions for the avoidance of doubt. So many of you will know the facts already, but very briefly, Ukhnafta was one of the Crimean cases. So in March 2014, when Russia absorbed Crimea, it expropriated Ukhnafta's petrol station business. Ukhnafta filed suit under the Russia-Ukraine BIT. The tribunal upheld jurisdiction in an award in 2017. Russia then sought to challenge that jurisdictional award at the seat in Geneva. And in this decision, the Federal Tribunal rejected that challenge, upholding jurisdiction, or the tribunal's jurisdiction in that case. Now, there were a number of issues, but perhaps the most relevant one focused on this, the meaning of territory and investment under the BIT. Now, Russia argued that because when Ukhnafta made its investment and when the BIT was signed, Crimea was Ukrainian territory. Therefore, Ukhnafta was a domestic investor, not a foreign investor in Russia. But the Federal Tribunal, unlike the Arbitral Tribunal, disagreed. Territory, it said, had to be interpreted dynamically, taking into account changes in the boundaries of territory. And importantly, this wasn't restricted to the internationally recognized sovereign territory. It included the territory over which Russia had de facto control. So in other words, when Ukhnafta originally invested, it was a domestic investor, and then from March 2014, it became a foreign investor. So why is this case so significant? Well, first of all, the Federal Tribunal was one of the first, I think in fact, the first national court to come to grips with jurisdiction in the Crimean cases. And its reasoning then helps set a precedent for other tribunals and courts. So in particular, it rejected the argument that the nationality of an investment was fixed at the moment in time that Ukhnafta had made its investment. It said that belonged to an outdated transaction-based approach in favor of a wider asset-based definition. And that reasoning has been followed. It's been followed most recently by the Hague Court of Appeal in July this year, in which it explicitly referred to the Federal Tribunal's reasoning in rejecting challenges to 4 Crimean's awards. Now, the second reason is that, sadly, this decision has gained significance since the start of the year. As we speak today, close to 20% of Ukraine is under Russian occupation. There's been asset seizures within those occupied territories. And as you'll see from the GAR article before you, Ukrainian businesses have already warned of potential claims against the Russian state. And as I was preparing my notes this morning, President Putin went on TV to announce that Russia would be supporting referenda on the annexation of 4 occupied regions, much as occurred in Crimea, and that those referenda could take place as early as this weekend. So we are potentially standing before a new wave of arbitrations by investors in a similar position to Ukhnafta. And lastly, after Ukhnafta and other claimants brought arbitrations against Russia, the Ukrainian Ministry of Justice saw, it seems, the potential value in investment arbitrations and in claims in international law more generally. And they've set up a website, which is lawfare.gov.ua, And if you go on this website, you'll see how the claims by Naftagaz, Oshad Bank, Privat Bank, and Arbitration, as well as various interstate cases, so under UNCLOS, the Genocide Convention, the European Convention on Human Rights, form part of Ukraine's legal arsenal. And what I find interesting is that often lawfare is, the term is used in a pejorative sense. But as we've heard this morning in the debate, ICCS, one of the main purposes of that is, of course, to provide a forum for the peaceful resolution of disputes. It allows a politically or militarily weaker party to compete on a level playing field. And one of its intentions is, of course, to do away with the gunboat diplomacy of the previous centuries. So I'm not a panelist. I can't say where we will be in 2032, but perhaps one of the global legacies of the Crimean cases, or that we see more cases, whether investor state or interstate, with these connections to geopolitical disputes. So for that reason, I think UKNAFTA is the most influential decision of the last 4 years. Thank you.
I just have a question of procedure. When did you choose the cases that you would talk about today?
I think it was a couple of weeks ago, or I think the deadline was the end of August.
Okay. And I don't know how much the rest of the room knows, but have all of the Crimea cases, as they are known, they followed a similar rationale on the issue of territoriality? Territory?
That's a good question. So to my knowledge, there were 4 cases, well, there were 2 cases decided the same day by the Swiss Federal Tribunal, so UKNAFTA and Stabil. There are 4 cases which have been upheld by the Hague Court of Appeal. Oshad Bank is still going through the French court system, so that was annulled by the Paris Court of Appeal on a different ground relating to the temporal jurisdiction, the temporal application of the BIT, and they've since appealed to the Cour de Cassation.
So we'll still wait to see what the outcome is there.
Exactly, watch this space.
Okay.
Robert, I'll bite. So I have some familiarity with the cases. I would question significance. I'm gonna stick with significance, and I'd say one could also argue, couldn't one, that the significance of the case is not how the majority ruled, but the fact that there was some dissonance, dissent, and consideration that actually that the territorial application was not as straightforward as it was seen. My understanding is that originally, and I'm not a Swiss lawyer, but understanding is that originally it goes to 3-member tribunal, and only if they can't agree it goes to the 5-member tribunal. That happened, which tells us that the 3 members couldn't agree. Amongst the 5, Justice Klett dissented, and 2 of the 3 changed their minds at the last minute. Could there be an argument that the significance is not in the strength of the decision as a precedent, but rather the nuance of the question that should give pause to future tribunals and courts as to the fact that there are significant jurisprudential issues that need to be weighed, as opposed to a one-track pony, which is easy to decide?
So there was a dissenting opinion in the decision. The identity of the dissenter isn't public, so I'll put that down to inside knowledge.
Yeah, I'm guessing.
But that was one of the issues that was subsequently raised before the Hague Court of Appeal, that it wasn't a unanimous decision in UKNAFTA. And the Hague Court of Appeal considered that, but ultimately it is the majority which forms the view of the court and which has persuasive precedential value. Obviously, the Hague isn't bound by anything the Swiss courts say. What I think the significance is that by the time of the UKNAFTA decision, there had already been several tribunal awards upholding jurisdiction, but ultimately those arbitrations would have come for naught if they weren't then recognized and enforced by the national courts. Now, I think the outcome perhaps isn't actually that surprising when you consider, back to the basics of public international law. Treaties applied to new territories from the date of their accession. That's the Moving Frontiers Rule. I think it's Article 29 of the Vienna Convention on the Law of Treaties. If you look at other cases involving, for example, extraterritorial application of the ECHR, the courts have looked at effective control or de facto control. And when you look at the facts of the case in UKNAFTA, it would be, I think, difficult to argue that a power or that a state has the power to expropriate, but then isn't bound by the protections against expropriation, so that you have the sovereign power to nationalize, but not to pay compensation for that nationalization. So I think the outcome itself isn't surprising, but the significance is that the national courts agreed with and upheld the reasoning of the arbitral tribunal.
I find fascinating this issue of dynamic territory. And maybe it's a bit of a PhD question, Robert, but will you think that this is just an exception, or rather, I mean, it has nothing to do, but it's a problem of territoriality when you think about whether to sue the EU under the Energy Charter Treaty or member states. So it seems like there is like some sort of fluidity on this conversation about dynamic territory. And I was wondering if we are allowed to speculate, if you think this is just an exceptional situation because what is happening in Ukraine, or do you think this might be food for thought for modern investment treaty making?
So I think that yes and no. So I think that there are sort of two strands to the arguments that were put forward about the dynamic territory. So that the first strand was that the notion of territory was frozen in time when the BIT was signed. And I think the Federal Tribunal had very little difficulty in dismissing that argument. And that goes back to Public International Law 101, that the treaties apply to new territories or to the states as they exist at that time. So as the territory expands or contracts, the treaty will apply to those territories as well. I think the more difficult point was Russia's argument that the foreign nature of investment should be assessed at the time of the making of investment. And the tribunal, if I can go back perhaps, so the Federal Tribunal actually went into quite a detailed textual analysis of the original texts in Russian and Ukrainian. The English doesn't really do it justice because it talks about investments which are put in by the investor of another contracting party. But the tribunal went to the original Russian and Ukrainian, and there's a long discussion about the continuous tense being used in this paragraph, which refers to an ongoing period of investment, and which it contrasted with the perfect tense used in other parts of the treaty where there was a very clear temporal cutoff. So it's perhaps a decision of interest to linguists as well as lawyers. So I think on that strand, that is potentially more limited to the Russia-Ukraine BIT, and it's possible that other treaties with different wording and different definitions of investment may come to a different result.
Okay, last but not least, we have Vishal Agrawal, who is an independent practitioner in India. Vishal is a dual qualified lawyer in England and India, who primarily focuses on commercial and investment arbitration and arbitration-related litigation. He holds an LLM degree from the London School of Economics, where he specialized in commercial and investment arbitration. He's the co-founding chair of India Very Young Arbitration Practitioners and ArbChat, an initiative that's been generated within his own Young ICCA mentoring group. Vishal will be presenting on the UK Supreme Court decision in Enka and Chubb.
I know I'm the last speaker. Please bear with me. I'm going to be crisp and I'm not going to be long. And I would ask Sharks if they can also pay their attention to the slides. Good afternoon, Sharks. My name is Vishal Agrawal, and I'm here to prove that Enka versus Chubb is the most significant decision in international commercial arbitrations since ICCA 2018. Before I talk about the importance of this case, I would like to quickly brief you about the facts of this case. Sharks, in this case, there was a construction contract where a fire broke out and caused damage to a power plant. The employer in this case, Unipro, in exchange of insurance money, subrogated its right to sue the subcontractor, ENCA in this case, to Chubb Insurance Company. It is important to highlight that there was no governing law clause in this contract. The dispute resolution clause stipulated that the dispute be settled through an ICC administered arbitration with London as a seat. Before I go forward, Sharks, I want you all to take a moment and introspect as to what is the most important element which acts as the foundation of international commercial arbitration. Yes, Sharks, you guessed it right. It is the arbitration agreement. Arbitration agreement is the underpinning on which the entire edifice of international commercial arbitration rests, and its validity is dependent upon the law applicable to it. Once you apply the wrong law, the arbitration agreement becomes invalid, and boom, everything falls to pieces. This is what makes this case extremely important. The law applicable to the arbitration agreement can have far-reaching consequences for the parties involved in the dispute. And we need to have a coherent, consistent, and certain manner in which this law is arrived at. Sharks, you may know that there have been previous authorities on this case, on this point of law, such as Sul America versus NSA, C versus D. But all these authorities, what they have done is they have continued to muddy the water on this vexed issue of proper law of the arbitration agreement. What I've done is, just to quickly take you through, I've put on this slide a tabular formation of the judgment majority ratio in this judgment. If you see the first row, where there is an explicit reference to the law of the arbitration agreement, there is generally no dilemma. It's very straightforward. It's only in the second case where there is no explicit reference to the law of the arbitration agreement, we actually undertake the entire exercise. So majority held in the second row in the first two cases is going to be the governing law of the main contract, which is going to act as the law of the arbitration agreement, generally. Then in the last case, when there is absence of governing law clause and there is no law of the arbitration agreement mentioned, we would resort to the law of the seat. And the law of the seat would also act as the law of the arbitration agreement. Now, Sharks, without taking more time, I would just put up 5 prominent reasons why this is the landmark decision. Reason number 1, it provides a clear test. Sharks, as you saw from the earlier slide, this case takes care of all the combination and permutations of the governing law clause being present or absent, law of the arbitration agreement being present or absent. It does not leave room for any assumptions. It takes care of all the contingencies. You apply the rule provided in the judgment and you will arrive at a proper law. It avoids a lot of complexity. Turning to reason number 2, it acts as a guidance for parties. This case is a clear example of unintended consequences if you do not draft the arbitration agreement properly. It teaches the parties that an arbitration agreement has to be drafted comprehensively and including every fine detail there is. And it also, with this guidance, reduces the further scope of disputes on this point of law. So this acts as a proper guidance for the parties for the future. Resorting to reason number 3, there is absence of regulations on this point of law. As Sharks, you would know that Rome 1 regulation is not applicable to the arbitration agreements by virtue of Article 1 to E. Also, in this case, English Arbitration Act was applicable because London being the seat. English Arbitration Act does not have any provision which prescribes as to how to determine the proper law of the arbitration agreement, unlike other legislations, other national legislations. Also, the institutional rules applicable in this case was ICC. ICC rules also does not prescribe any way how to arrive at a proper law of the arbitration agreement. So hence, in my opinion, this case actually fulfills a very important legal vacuum in legal jurisprudence. Resorting to reason number 4, Sharks, it ensures enforceability of the award. Sharks, you know that the enforcement of awards is the crown jewel of international commercial arbitration. We want to make sure that the arbitration agreement is valid in the first place to ensure that the award is enforceable at the end. And secondly, and more importantly, we have a conflict of law rule to determine the law of the arbitration agreement within the New York Convention. If you see Article 5.1a, it says that the arbitration agreement has to be valid under the law chosen by the parties or under the law under which the award is made. So it basically says that law chosen by the parties or the law of the seat. And this is the ruling which has also been applied by the majority in this case. So this judgment is in compliance with international law, which again reinforces the idea that award would be enforceable at the end. Now, lastly, there is a consistency with this decision. If you see other jurisdictions such as Singapore, In the case of BCY versus BCY, the Court of Appeal in Singapore held that in such situations where there is no governing law clause in the contract or the law of the arbitration agreement is absent, we would resort to the law of the seat as the law of the arbitration agreement. Also, you would see that subsequent English cases have also been applying this principle in further their cases. For example, in Kababji, English court again applied this principle to arrive at the conclusion that English law would actually be the law governing the arbitration agreement. Shucks, all these things only point to one and one thing, that this decision is the most significant decision in international commercial arbitration since ICCA 2018. And if I may add, without having the arbitration agreement in the first place, there would be no appointment of female or male arbitrators. There would be no appointment, there would be no issue of delegation of power to the tribunal secretaries. And at the end, I would say there would be no banana to peel. So,
I love it.
so I want to thank you. I want to thank you for your time and for your patient hearing.
Thank you. Excellent presentation. But let's challenge it a bit. So the idea was that what is the law governing the arbitration agreement? And the answer was whatever the seat that law governed, despite what was in the governing law of the master agreement. In theory, I like it because we as arbitration lawyers have the theory of separability. We take the arbitration clause out, which is its own agreement. And therefore, it makes sense that the closest connection to the actual arbitration agreement, if you take it as a separate clause, the seat gives you an idea of what the parties intended. But that's theory. And we have that separability theory. It's an artifice, really. And we have it because if the contract fails, we don't want arbitration to fail, right? And that makes sense to me. But in reality, as Lord Burroughs said in the dissent, right? In reality, if you sat down with the parties at the time and they were negotiating the contract, for them, the arbitration was just a clause. It wasn't a separate agreement, right? It was just a clause. And if you ask them, what's the law governing your agreement? They'd say Russian law, right? Which was at the time. So my question to you is this decision one of following the artifice of separability of the arbitration clause? And I agree on the consistency, but frankly, I think there could have been consistency either way. Whichever decision they've come to would have been clear consistency. The question is whether it was right or wrong. And I'd say I like the dissent better because I think had you asked the parties, what is the law governing your agreement? They would have said Russian. And they probably would have said all clauses, including the arbitration clause, because in their mind, it wasn't, oh, but of course, under arbitration, that is a separate contract which has its own separate governing law. So are we really following a jurisprudence of theory as opposed to a jurisprudence of reality?
I think it's a very important question. And I think what has happened with this judgment is when I was reading this judgment, if you read it with a fine-tooth comb, you will realize that the issue was not exactly about proper law of the arbitration agreement. The issue was about what was actually the law governing the contract. Because if I take you back to the slide, you see that I mentioned there that if there is an implied choice by the parties, then in the main contract, then that implied choice of Russian law is also going to be the law of the arbitration agreement. So the real issue was whether the contract has an implied choice of Russian law or not. So they did not say that we're going to separate out arbitration agreement and then decide what law is going to be applicable. What the real issue was, if you see the judgment, was that whether the Russian law was actually the implied choice of law of the main contract or not. And there, if you see, the majority and minority has differed on the point that majority says that it usually happens in construction contract that you might have to comply with a lot of laws of a particular place where the construction is going on, but that not necessarily mean that the entire contract is going to be governed by the law of that place. So, but minority says that there is a hint of Russian law all over the contract. So where do you draw the line? So they say that if they had to include the Russian law, they would have said it explicitly that this contract is going to be governed by Russian law, but they didn't say that. So the real issue here is whether impliedly did they choose Russian law or not. I myself agree a lot with minority, but I have my own reservations as well, because some of the arguments did not seem fit to me. For example, they talk about conflict of law rules in New York Convention. They say that you can check the arbitration agreement according to the law, which is arriving at New York Convention only at the end when you're enforcing the award. That means what they're trying to say is you're going to apply different conflict of law rules in Article 2.3, where you're checking the validity of the arbitration agreement, which doesn't seem right. You see the fallacy in that argument that you're going to apply different conflict of law rules in the beginning, and you're going to apply different conflict of law rules at the end, and you might arrive at a different law applicable to the arbitration agreement. So there are certain points like that in the minority, which does not seem right to me. But for me, how I read it is that the real issue was whether the implied choice of the main contract was actually a Russian law or not. So their majority had that it was not a Russian law. So that's how they said that if there is an implied choice, we agree it's going to be the governing law of the main contract, which is going to be applied to the arbitration agreement. But here we don't say there is an implied choice. So arbitration agreement is going to be governed by the law of the seat.
Yeah, Vishal. So, to which extent do you think that the ENCA versus Chubb has any impact on jurisdictions across the channel?
Excellent. That's a very astutely observed observation. I have an answer to that. So I'll tell you. So
too predictable.
Prearranged.
Whatever you're selling, I'm buying. I like it.
So I know. So you would obviously say that civil law countries do not abide by that. And we have an example in France where Kababji happened, right? But there are other civil law jurisdictions as well who do abide by this decision. For example, you pick up the case of Bulgarian Bank versus AI Trade Finance. This was a Swedish case where they said that this is how it's going to go. Even if the laws of Austria are the main laws of the contract, we're going to go by the law of the seat, and we're going to stick to this principle. We have another case of, if I'm pronouncing it right, Australi versus SRL. It's a Dutch Court of Appeal case. And they also said the same thing. They said that even if there's a absence of the law of the arbitration agreement, and if there is a main clause, main law of the main contract, they talk of something such as validation principle, which I did not want to confuse my audience with, but yes, so they basically arrived at the same result, that law of the seat is going to be the law of the arbitration agreement.
Thank you.
So if we were on TV, at this point, we would be asking the Sharks to vote for a winner and also part with some of their hard-earned cash. But we're going to spare their blushes. What we're going to do... I'm sure.
We don't have any.
What we might do instead is, if you use the same QR code as you used in part one, you can vote for whoever you think gave the most convincing, compelling, persuasive presentation. And we can reveal the winners at the end. I'm going to pass now to my fellow co-chairs who are going to make some closing remarks. But before I do, I just wanted to invite everyone to give our presenters and our panelists a big round of applause for being here.
So we asked you at the beginning of this afternoon to join us on a three-part adventure. We've gone through parts 1 and 2, and it's now my chance to say thank you to the guides that have led us on this adventure. First of all, I'd like to thank Kate, Gloria, Nusha, Baiju, Tiffany, and of course Panos. Can we get a round of applause for them again, please? Our very brave participants that faced an aggressive pool of sharks, Jessica and Naomi, Raul, Daria, Robert, Vishal, thank you. As Manas said at the beginning, one of the great things about Young ICCA is the platform that it provides to young advocates to showcase their talents. And I think you've all seen today what the young generation of international arbitration advocates is capable of. And it fills us all with excitement to see how strong that pool of young people is. So there were a lot of people involved in the background in this event, our regional representatives, some of whom are in the room today, Paul Mateusz. There were many people as well from the Young ICCA committee involved, Lise Bozeman, Lucy Reed, Lisa Bingham, Yoshimi Ohara, Mohammed Abdel Wahab, Summer Hariri. Thank you to Andrew McKenzie from the Scottish Arbitration Centre. Thank you as well to the ever impressive Lucy Burns and Araba Akezi Maison for all of their hard work in helping us to put on this event. And I realize that today is one of the most important days of the year in New York. It's the United Nations General Assembly. You chose to spend today with us rather than watching the UNGA. So thank you.